Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. We've previously reported about the requirement for companies and limited liability partnerships to maintain a People with Significant Control, that's a PSC register, from April. The Small Business, Enterprise and Employment Act provides categories of people that will be deemed PSCs, but the missing part of the jigsaw has been who is included in the final vaguely worded category, namely those that have a significant influence or control. We now have draft guidance on the meaning of this category. The guidance states a person has control of a company when they have the power to direct its policies and activities, and significant influence when they can ensure that the company adopts those policies or activities. The draft guidance also provides a non-exhaustive list of safe harbour roles that, providing they do not exceed what would normally be expected of such positions, will fall outside the definition of a PSC. Now, these include professional advisors, persons engaged in third-party commercial agreements, i.e. suppliers, customers or lenders, employees and directors of the company, i.e. managing directors, sole directors or non-executive directors who hold casting votes. The consultation on the draft guidance closed on January the 11th and the finalised guidance is expected soon. A recent real estate case, Marks & Spencer's v BNP Paribas Securities Services, has provided some helpful general commercial guidance concerning implied terms. Now, in this case, M&S had exercised its right to break the lease, and although it was not expressly stated, it argued that it was implied that it would be entitled to an apportionment of the basic rent and other fees. The High Court agreed with M&S, but this decision was reversed by the Supreme Court. Now, the Supreme Court confirmed that there are two types of contractual implied terms, namely, one, a term that is implied into a contract in the light of the express terms, commercial common sense and the facts known to both parties at the time the contract was made, and two, terms that are imposed by law. Now, existing law BP refinery case is already clear that any implied terms must be reasonable and equitable, necessary to give business efficacy to the contract, and be so obvious that it goes without saying, be capable of clear expression, not contradict any express term of the contract. The Supreme Court agreed with the existing law but did place some qualifications on it, stating that the test for a term to be implied into a contract is that it must be either so obvious as to go without saying or only be implied if without the term the contract would lack commercial or practical coherence. It is clear that following this case that parties seeking to rely on implied terms will face an uphill struggle. Factors such as fairness and subjective intentions of the parties are unlikely to help. Companies that have pending VAT overpayment claims may need to wait a little longer. In June last year, Littlewood successfully argued that compound interest should apply to its VAT overpayment claims, but the HMRC has now been granted to leave to appeal to the Supreme Court. It is understood that Littlewood's claim exceeds $1 billion and that many businesses have claims pending the resolution of this lead case. The Commercial Agents Directive ensures that on termination, agents have the right to a termination payment on an indemnity or compensation basis. The directive describes the indemnity alternative as being in respect of new customers brought in by the agent and any increased business that the agent generates with existing customers. The indemnity is capped at 1 year's commission. Now, many member states have implemented the directive into national law by providing only for the indemnity alternative. English law allows the contractual parties to choose indemnity or compensation, but if neither is stated in the contract, then the indemnity will apply. Now, the issue that arose in a recent Belgian case is whether agents are entitled to receive damages under national law on top of the capped indemnity. The Court of Justice of the European Union ruled that the indemnity is not intended to cover all types of loss, and therefore member states may offer damages under local law, in addition to the damages available under the indemnity. Importantly, however, the additional damages must relate to something other than what is intended to be covered under the indemnity and not therefore the simple fact of a unilateral termination of the agency agreement, e.g. an incorrect notice period. It is expected that large companies will be required to report biannually on their dealings with small businesses from April 2016. This measure is part of the government's drive to help small businesses tackle poor payment practices by large businesses. We understand that the reports will include information on average payment days, payment terms, and the availability of e-invoicing. In December, we finally received clarity on the long-awaited General Data Protection Regulation, the GDPR, that will be directly applicable and effective in 2018. The GDPR brings many changes, but the headline feature undoubtedly is that companies may be liable to pay penalties of up to 4% of their total worldwide turnover. That's a staggering leap considering that pre-2010 the maximum fine was £5,000. The directive includes requirements on companies to appoint data protection officers in certain circumstances, to notify data breaches to the relevant data protection authority within 72 hours, to conduct privacy impact assessments before they carry out high-risk data processing, and to build in privacy by design processing for personal information. Our bulletins would not be complete without another example of a serious data protection failing. This time it's the term of the Alzheimer's Society. The Information Commissioner's Office, the ICO, found that the charity's volunteers used personal email addresses to receive and share information about people who use the charity, stored unencrypted data on their home computers, and failed to keep paper records locked away. The volunteers had not received any data protection training. The recent Court of Appeal case, Griffiths v Secretary of State for Work and Pensions, has made it clear that policies that require a minimum level of attendance to avoid disciplinary action will be subject to the duty to make reasonable adjustments for some disabled employees, otherwise they may be at a substantial disadvantage compared to their non-disabled colleagues. A recent Employment Appeal Tribunal case, NASA v NHS of England and Coventry City Council, provides a warning on the need to exercise caution when giving and receiving an employee reference. In this case, the former employee's manager provided a reference that warned the prospective new employer about the employee's sickness absence. The sickness was connected to the employee's disability, and she successfully claimed against both employers. The EAT held that the employee did not need to prove that discrimination had taken place, merely that the unfavourable reference related to her disability. We have previously reported about the ODR Platform, which will be an interactive website designed to help consumers who have bought goods or services online and subsequently have a problem with that online purchase. The ODR regulation obliges online traders selling to consumers to provide an electronic link to the ODR platform on their website and within an email if the offer is made by email from the go live date. The go live date was the 9th of January, but has now been delayed until the 15th of February. The Competition and Markets Authority, the CMA, has launched a market study into the supply of legal services in England and Wales, examining competition and consumer protection issues to see if they are working well for consumers and small businesses. In the last few weeks, we've seen several bribery-related cases hitting the headlines, including Smith & Ouzman Limited. This printing company based in Eastbourne has been ordered to pay a total of £2.2 million after being convicted of making corrupt payments to public officials for business contracts. The company's chairman and sales and marketing director have also been given jail sentences. Barclays Bank has been fined over £72 million by the FCA for failing to minimise the potential risk that the bank could have been used for facilitating financial crime. The case is particularly noteworthy as no crime had taken place, but nevertheless the FCA wanted to set an example after it was found that the bank had applied an unacceptable low level of due diligence to high-risk transactions. And Brandrex Limited. We understand that this is the first failure to prevent bribery case under the UK Bribery Act. In this case, the company had run an incentive campaign whereby its installers were rewarded with prizes, including holidays for hitting certain targets. That was all fine except that one of the installers decided to pass the holiday to an influential employee of one of its customers. The facts here are interesting given that they relate to the provision of hospitality, which has often been considered a grey area that could unwittingly catch otherwise reputable companies, and that the deed was done not by the company but by a third party acting on its behalf. The company has, however, been considered lucky that its punishment was a relatively modest £212,800. This was a Scottish case, and the company managed to avail itself of an initiative that is understood is no longer available in Scotland, and a similar outcome would have been unlikely in any event in England. Transparency International UK, TI UK, has published new guidance for companies on political engagement. The guidance sets out 10 guiding principles for managing political engagement and covers a wide range of activities. It is of relevance to all large companies and smaller companies that are likely to have any such interaction. TI UK has also published its Corporate Political Engagement Index, which assesses the public reporting practices of the 40 largest companies in the FTSE 100 in relation to political engagement using publicly available information. TI UK found that the majority of companies currently perform poorly. Thank you for joining us for this month's commercial bulletin. The website details of Radius Law and LexisNexis will be shown on your screen in a moment. Please feel free to contact me if you'd like more information on any of the topics covered, and if you have not already done so, you can get access to more content with Lexis PSL. Please don't hesitate to contact my colleagues at LexisNexis to request a free trial. Any other feedback on our bulletins is, of course, also welcome. We'll be back next month with another update. Until then, thank you and goodbye.